Good morning, everyone. Thank you for joining us here for the Moot Court competition. Before we begin with the preliminary round of this event, I would like to take this opportunity and tell you about our judges for the preliminary round. Our first judge is Advocate Mayuri Hatle ma'am, who is the advocate of Bombay High Court. Ma'am has led several cases in the Bombay High Court. She has been appointed as the Vice President, Women Advocate Wing, Maharashtra by the All India Federation of Advocates and Associations, New Delhi. Mayuri Hatle ma'am was also awarded the Best Budding Lawyer Award by Vidhi Foundation Thane in 2015. Ma'am has been recognized amongst the 40 under 40 top lawyers. It is our utmost pleasure to have you here as our judge, ma'am. Thank you so much for accepting our invitation. I request you to share a few words with us today.
Very good morning to all. It's a good opportunity for me to be a judge at this national level Moot Court, first of all. And I would like to thank the college authorities for letting me given my support and some kind of contribution to the students who are budding lawyers. And for all the students, I would only say that it is a good opportunity. Please do take part in as many moot courts as you can. It is only a good opportunity for you to start early in your practice, because such kind of moot court will only help you to kind of understand the kind of lawyer you yourself are, where do you stand as far as your orientation is concerned, your language is concerned, your oratory is concerned. So I would just say all the best to all the students, and it is a good thing that you've taken part. Winning is not the ultimate thing, but the fact that you've taken part in this competition is a very good thing. All the best to all the students. That's it. Thank you.
Thank you so much, ma'am. True words, Moot Court competition is indeed a stepping stone towards a good practice. I would now like to introduce our second judge, Vrinda Daga ma'am. Advocate Ms. Vrinda Daga is the founder of VR Law. She has completed her graduation in BA Honours Economics from Sophia College for Women, Mumbai, and has earned her law degree from Kishanchand Chelaram College of Law, Mumbai. She is recognized as an advocate with the Bar Council of Maharashtra and Goa after working with a prestigious law firm in Mumbai and practicing as an independent advocate before various courts of law, tribunals, quasi-judicial authorities, etc. Ms. Daga has specialized in negotiation, due diligence, corporate legal structuring and restructuring, alternate dispute resolution, and documenting contracts, etc. She has been invited as a guest lecturer in colleges to share her legal knowledge and expertise. Thank you so much, Vrinda ma'am, for accepting our invitation. I request you to share your thoughts with us today.
Good morning, everyone. It's indeed a pleasure to be a judge for the Moot Court competition. When we were in college, we have also we've attended Moot Court competition, so we know there's a lot of pressure. Don't take so much stress that, oh, you have to reach the bar or you have to do the best. Just perform, go ahead, and I'm sure you will do well. All the very best to all the participants.
Thank you so much. I would now like to ask the Moot Court Association head, Ms. Chanchal Singh, to take over from here, and she will take you through the rules and regulations of the competition. Thank you so much.
Good morning, everyone. I, the Moot Court head, Ms. Chanchal Singh, would be reiterating the rules for the oral submissions for this Moot Court competition with VidhiTaksh 2023. So, as stated earlier, that each team in the preliminary round will be given a maximum of 25 minutes, in which the further bifurcations are 18 minutes for the arguments, 5 minutes for the cross-examinations, and 2 minutes for the rebuttal. In the 18 minutes of arguments, the mooters may further divide their time as per informed to the group, and we may now start with the competition. The first teams that would be competing are VTM03 and VTM01. Thank you. All the other teams except for VTM-03 and VTM-01 kindly leave the meeting. It is to be stated that the competition may begin. So VTM-03, who is behalf of the state, may please start speaking.
The council seeks permission to approach this honorable bench. The bench and the council will approach this bench as collectively as your ladyship. If the ladyship is well versed with the facts, can we start the argument?
Yes.
Yes. Over here, the issue number 1 is the council would be starting dealing with issue number 1, 2, and 3, whereas my learned council will be starting with co-council will be starting dealing with issue number 4, 5, and 6. The issue number 1 over here is whether Aisha Yadav's second mobile phone's evidence is admissible in court of law or not. The council would like to admit the evidence which has been collected in the second mobile phone, as this mobile phone is Aisha Yadav's personal phone and has many evidence in it. As we are well versed with the fact that the mobile phone has security systems which is only operable by Aisha Yadav, and there is a special recording system which can only be accessed by Aisha Yadav, and all the recordings are over here been recorded. So there are chances that the recordings might be useful for us as corroborative evidence. Whereas in issue number 2, the statement made by Aditi is admissible in court of law. Yes, the learned counsel thinks fit that Aditi, being a 10-year-old girl, she is adult enough to understand the circumstances and the questions which are being put forward in front of her. So her statement should be admitted, and Aditi is a reliable witness. Whereas issue number 3 is whether the evidence stolen from the crime scene is admissible. Yes, the crime scene evidence is to be admitted as Aisha Yadav being the sole operator of the mobile phone. There are no chances of anyone tampering the evidence or anyone who has manipulated any kind of facts or any data in the mobile phone, which the mobile phone was not even being opened by the authorities themselves. So it is very safe to admit all the facts which are being stored in the mobile phone, even if the mobile phone was presented before the police investigating officers later on by witnessing Aditi. Yet, because the evidence is not at all tampered or manipulated, we can admit all the stolen information and all the evidence which are being collected from the mobile phone. The co-counsel will start with the further issues. The issue number 4 is Dr. Rasim and Yash subjected to narco analysis or not. It is submitted that Dr. Rasim and Yash are not subject to narco analysis, as Dr. Rasim may have sufficient knowledge which he can use to manipulate the readings of the narco analysis test, and he is being a scientist. He know how to control his hormones during the narco analysis test. He can control and manipulate the test as well. Whereas Yash, being a witness, cannot.
I will just stop you here. How can he manipulate himself or his statement during the narco analysis? Can you just elaborate on that? How is it possible for Mr. Rashid to ask him to do that?
Being a scientist, he knows how to control his hormones. Like when the narco test is conducted,
Counsel, are you aware of what are the requisites of a narcoanalysis test?
sorry,
Are you aware of what are the requisites of a narcoanalysis test?
kindly grant us some time. Our researcher will get into it and we'll let you know.
Okay. Yeah, continue.
And yes, being a witness cannot be subjected to narco analysis. Issue number 5, Dr. Rasim can be charged under section 316 of IPC. It is submitted that as Dr. Rasim did not wanted to have a baby and believed he is not the father of the child, is sufficient ground to charge him under section 316, as many a times he being a violent on her and started abusing her on the fact that he is not the father of the child and refused to
Counsel,
be.
the question over here is, can he be charged under section 316 of the IPC? What does the section says?
16 is a person knowingly whoever does any act.
Don't read the section. Don't read the section. You just interpret it in your own words.
Yes. It is a culpable homicide since the Rasim Khan, knowing the fact that Aisha was pregnant at that time, and even though he was violent as stated in the postmortem report, the injuries found on the body of Aisha, on her right wrist was fractured, and on the right side of her face it was injured. It shows that between them there was some violence.
Is there any evidence on record to show that there was a violence which was done by Mr. Rasim only?
Preposition.
When you're talking about evidence, is there any evidence to that record?
There is no such direct evidence, but my learned counsel in his written argument stated the fact that at the heat of the movement, he was being a violent on the on Aisha Yadav. It is submitted by the learned counsel itself only.
Who submitted it?
The learned counsel argument, written arguments. Written arguments of the learned counsel clearly states that there was heat of the movement which resulted in death of Aisha. So, as Aisha being a mother at that time, she was pregnant, which is well versed with Dr. Rasim. He was knowing that his wife is pregnant, and during that moment, if he attempts to kill his wife or he kills her wife in the heat of the moment, which clearly indicates that he indirectly is liable enough to attack 316 session of IPC. Is the case fit for the court to charge under section 302 of IPC and try the accused person? It is submitted that the circumstances of the case frame the charges under section 302 of IPC, as Dr. Rasim Khan was the last person who had interacted with Aisha before her death, and the conflict between them was serious enough for the Dr. Rasim Khan to take such action. Hence, the case is totally fit for the court to charge under section 302 on Dr. Rasim Khan.
Sorry, can you just repeat what you said in the end? The case is?
The case is fit for the court to try charges under 302 on accused. In this case, it clearly shows that Dr. Yasim Khan and Aisha had many conflicts between both of them. So it is clear. It clearly states that during the argument, the Dr. Yasim Khan was not even happy with Aisha getting pregnant, and he denied.
Counsel, I would just like to ask you.
1 minute left.
On the night when she waited at his house,
Yes, ma'am.
is there any evidence to that tune or any statement of the girl that such kind of fight or any kind of physical assault had taken place between these two? I'm saying about proper evidence. I'm not saying about your proposition that you're proposing that thing. I'm asking about any kind of preliminary evidence at least.
If you look at postmortem report and the investigation done by the police officer, it has clearly
Counsel,
shown.
my question is not about what is in the Panchnama or in the postmortem report. I am stating only, was there any evidence to that record that any kind of physical assault had taken place between this lady and Mr. Asim?
There are circumstantial evidences which clearly gives an indication that there has been many conflicts. As earlier also, Rasim had the time frame starts for another mooter. The council would like to seek some time if the leadership permits.
No, not allowed.
The council seek permission to start with the cross examination. As per the written argument filed by the learned co-counsel, they have approved.
Excuse me, I humbly apologize for interrupting. That the mooters are informed that only 9 minutes have been done and that the time frame for only one mooter has been completed. The another mooter still has 9 minutes to argue. Thank you, Your Ladyship. Thank you.
The mic is on mute, I guess. PTM 03.
Good morning, ma'am. Should we speak?
No, I think VTM 03 is yet to complete.
Yet to complete, right? So 9 minutes still to your.
Some range problem. Sorry.
Okay.
And regarding the issue number 1, that Aisha Yadav's second mobile phone evidence is admissible in court of law or not. Regarding that, the phone containing the feature that record the voice around surrounding the phone and as well as the telephonic conversation surrounding the phone, as Mr. Yash left home at 10:30 and rest time was with Dr. Rasim, and Aisha and Aditi was home alone, and the phone taken by the Aditi was after some time. So between them there is a possibility that the conversation between Aisha and Rasim took place, which can be admitted as an evidence. That if the phone admitted as an evidence, then it can prove as an evidence that some conflict or some conversation had taken place at that night. And the ambiguity that has arisen, this would be helpful as the learned leadership, have pointed out, whether there are any evidence or not. If we find out the recordings, and if the recordings are being admitted by the learned by the leadership, then it will be very useful to understand the nature and the event which happened took place between both of the parties. As it is stated in the fact that Aditi had slept. So there might be chances that the recording which was on in the mobile phone have captured the conversations or the conflicts or any kind of sound recordings which had happened during that moment, which no one else was present over there. So this is very vital to get the recordings of the second mobile phone admitted, as it will play a huge role in finding out and clearing all the ambiguity which has arisen. As Yash was also present with Aditi and with Aisha and Dr. Yasin Khan till 10:30. There are chances that the mobile phone has also recorded the conversation which took place between 10 and 10:30. There is which would reveal that what was the behavior of Dr. Yasim Khan when Yash was present, and thereafter what was the behavior which changed in his behavior after he left. Linking all the evidences which will be found in the recordings of the mobile, it will be beneficial for the for to get the justice to the victim, as it will help in identifying the behavior or any kind of changes which took place in the environmental circumstances between both of the parties after Yash left. So hence we require the mobile phone to be admitted, and all the recordings of the mobile phone to be retrieved and be submitted for the honorable court. Regarding the second issue, statement made by Aditi is admissible in court, as there is no such direct evidence that defines the cause of death of Aisha. There is only one witness present over there, the crime scene, that is Aditi. Aditi's statement may constitute the relevant fact or evidence that can help to come to conclusion, as High Court decided that under Section 118 of the Indian Evidence Act, every individual is competent to be a witness in a court of law unless incapable of understanding the question placed before him. It does not matter that what is the age of a witness. What matter is ability to understand the situation that arises in front of such person. It was held that by considering the credibility of the juvenile witness, the trial court may, by taking into account the fact that the judge may have the first and direct conversation with the child, and enables him to be the best evaluator of the child's level of development and comprehension. Evidence stolen from crime scene, admissible or not. The sole evidence that was found at the crime scene was Aisha Yadav's mobile phone and nothing else. But at the time of investigation, police officers seized the second mobile phone of the deceased that was recovered by Aditi. Aditi taken mobile phone.
Counsel, the situation over here is that the phone data is not being retrieved, or it has not been able to be retrieved. So that is only left at the behest of this person named Mr. Yash. So what if the condition that he's not able to retrieve it? Or
Yash is an ethical hacker. He knows all the tricks and all the
so the prosecution, can the prosecution leave some kind of evidence at the redressal of another co-accused or a suspect or a probable suspect? Can that happen in such case?
Council is asking the leadership to permit the police officers to show it to an ethical hacker who is capable enough to handle such kind of cases. As Yash himself being a ethical hacker, he is confident enough that he will retrieve the data. There are many possible chances that the state has many officers who are a ethical hacker and who can easily retrieve the data.
Yeah, but the person who first saw the body, or he is putting forth that theory before the prosecution, is Mr. Yash only. So the entire theory is dependent on the statement of Mr. Yash. How can the prosecution believe him?
We are not asking the leadership to believe on Yash himself totally, as even Yash is a suspect, and there are many chances that he is the one who might have committed the crime or any such offences.
1 minute left.
The council would like to finish off the sentence if the leadership comments. The Yash. Yash, we cannot rely solely on the Yash's statement, as there may be chances, but there are no circumstantial evidences which will state, or there is no link that Yash can be a person who have done such kind of crime. As Aditi was very close to Aisha, he will not risk putting her own daughter in such kind of grievous loss of the loved one.
That is the case of that child comes into picture.
She is a witness who was present at the night when the incident took place. So she might have overheard the conversation or the fights if there would be any chances.
Time up.
Council would like the organizer to clarify whether the time is up for the speaker or it is up for the cross examination as well.
Cross examination starts now.
When the counsel would like to focus mainly on the written argument which is submitted by the learned counsel. Over here, they would like to state that the learned counsel have clearly mentioned that they have come and they have approached this honorable court for in the matter of an appeal. So the jurisdiction over here is completely denied, and the council would like to dismiss the case as the facts and the incidents are already accepted by the learned co-counsel. They have already convicted the accused person over here, and they have admitted all to the facts that the person has been convicted for the charges of 302. And whereas regarding the issue number 1, whether the evidence from Aisha second mobile phone is admissible in the court of law, the learned counsel have also agreed that yes, the evidence from the second mobile phone should be admitted. And issue number 2 has also not been denied over here, whether whether Aditi's statement is to be admitted or not. The council have clearly accepted that the statement.
Sorry for the interruption, but the VTM 03 needs to understand that cross-examination is only for following witnesses, and the points they are keeping are for the rebuttal round.
Okay, ma'am. Whereas the issue, whereas the ladyship have asked the question regarding the narco-analysis test. The narco-analysis test is conducted to detect the lie detectors and the brain mapping. Dr. Rasim is himself a scientist and is a PhD. PhD has done a PhD, and he
PhD in what? But
the facts are silent on this.
so how can you term that thing that he is able to manipulate his hormones? I mean, this is a very hypothetical statement that you're putting across the court, that he can manipulate his own hormones for the narco-analysis test. And now, as it is, you are for the cross-examination. Just continue with the cross-examination. I mean, it is going a bit haywire.
Do you have an answer for the question that ma'am has asked?
Well, ma'am, the facts I have not mentioned whether Dr. Yasin Khan have done his doctorate in which. So I am not able to answer to the question that he has done his PhD in what?
No, so then the question as rightly asked to you was that then how will he manage his hormones? Like what kind of scientist is he? Are you able to justify that?
Yes, ma'am. When in narco-analysis test, not all the hormones are been, if a person, after asking a question, if the person gets stressful, then his hormones started increasing. And if a person is well versed that how to be calm in certain situations, then he can easily manipulate his hormones. He can he can hide the stress level and the impulse that his body would build. So this can be very dangerous to completely rely on the narco-analysis test. But whereas
Counsel, what is your point? I mean, you're saying it is dangerous to depend on narco-analysis test, or you are from the prosecution side, right?
yes, ma'am.
So what is your case? I mean, are you able to even put forth your case properly? Which way do you want to go?
The fourth issue is regarding the Dr. Rasim Khan and Yash subjected to narco-analysis.
1 minute left.
We are stating that we don't want the Dr. Rasim Khan narco-analysis as we just simply don't want the narco-analysis of Rasim Khan as an accused, and also the witness Yash. We also don't want Yash narco-analysis as he is being a witness. Whereas Dr. Rasim Khan was teaching Aisha herself in a doctoral study. And a doctoral study, a person is well versed that how a lie detector and a narco-analysis test work. They are the ones who have a proper study about how the body responds to this.
Time up.
it is kindly to be announced that the times for the cross examination has ended and there are only 2 minutes left for rebuttal.
And also, the Indian judiciary does not totally rely on the narco analysis tests. And for the rebuttal,
Counsel, in which cases does the Indian judiciary has not relied as of now on narco analysis test? Can you just name any kind of test in any
yes,
cases?
Sonakshi.
Can you just name that?
Uh, just a second, ma'am. State of Bombay versus Kathikalu.
Year,
Yes.
what is the year of the citation that you're stating, counsel?
Yes. Just a second. Just a minute, ma'am. It is Yogesh at Charu Anand Chandane versus State of Maharashtra. It's a writ petition number 2420, which was filed in 2016. In this, it has been stated that the evidence recorded in the course of narco analysis test or polygraphic test is not admissible evidence. Just clearly stated by the Bombay High Court. And whereas,
Can you just give me the ratio, exact ratio of the citation? You just read the statements in between. You just give me the ratio of that particular citation which you stated now.
there are no particular ratio as in such.
There is a ratio to every judgment.
We are not well versed with the ratio of the fact that
Time up.
the counsel would like to seek permission to rebuttal on the written argument given by them.
No.
VTM01, kindly switch on your video.
Ma'am, it says host has disabled it.
It is to be stated that there is no, like we have not disabled your video from our side.
Because I am trying to on it, but the message is displayed that you cannot start your video because the host has disabled it. I'm getting the message on the screen itself.
Can you click the picture of that screen and send it to the WhatsApp group?
Yes. I'm trying. Good morning, ma'am. I'll start from this because my video is not being displayed.
Sorry, we can't hear you. You're on mute.
Good morning, ma'am. I plead not to be guilty on my behalf of my client Rasim Khan. As we can see from the arguments done by my learned counsel, we would like to share that first, on the first issue we'll be discussing, whether the evidence from Aisha Yadav's second mobile phone is admissible in the court of law. It is yes, under section 65A and 65B, as per the Evidence Act, in 2000 it was added that these are allowed. But here the evidence holds no truth since the mobile was with Aditi and she slept in the guest room and Aisha was found dead in the other bedroom. So the mobile phone was lying with Aditi itself. So that mobile could record or not record it. That thing we should see. And it was in the other room, so it might have not recorded the conversations in the room which Aisha was murdered. On the second statement, whether the statement made by Aditi is admissible in court of law. Under section 118 of Indian Evidence Act, anyone is considered capable enough to testify in the court of law. It is stated that all persons are capable of testifying unless the court sees that they are stopped from comprehending the questions put forward or from providing rational answers to the same because of their sensitive age. The above provision does not hold true actually. In the landmark case S. Amutha versus C. Manivanna Bhupati in the year 2007 laid down that testimony from 10-year-old, the evidence of child witness and credibility thereof would depend on the circumstances of each case. In this case, now the 10-year-old can be manipulated in any manner. If you tell him or her that such fights happen every day in between the couple, she might have seen the fights between her parents also. So this not lead to a murder of someone. Such fights cannot lead to a murder of some person. So I think the Aditi has, is capable of testifying. We should understand that is she sensible of answering such question? If in moment of time, if further evidence has.
What is your answer to this question? In yes or no, I would just like to understand.
No, ma'am.
She is not capable to testify.
I think she is not capable because she is a young lad and she is not as in the case also we had seen that she throws tantrums to get herself.
Just in the first issue, you said that she was sleeping in some other room and
yes,
she knew the recording must have taken in some other room and the
other room
has taken place in other room. So what is your fear in letting her to give the statement then?
She can give her statement.
Then?
But she was, I'm saying that her statement might change with time.
No, I want your precise answer. Either it can be yes or it can be no. It cannot be either or, neither nor. It can't be that.
I say it's no from my side. Because she was sleeping in the other room and the statement might change. Or in manipulation, she can give another statement. Like Yash might say, because Yash also has got into this because he has broke into the house without permission of the client, Rasim Khan. He has broken the house and he has.
Why was the permission required? His daughter was stuck inside. He was not able to trace down his daughter. For that purpose, he has broken out the house. He isn't barged into the house for the purpose of doing any kind of robbery or something. It was only for his daughter. So nothing. Why should he be at stake?
But ma'am, he should have asked. He should have called Rasim Khan and he should have asked his permission. If whether he has left some keys or he should enter it, or without asking him, he has entered the house. That is the thing over there.
Yeah, continue.
And for the third point, whether evidence stolen from the crime scene is admissible in the court of law. Under the Indian evidence law regime, an illegally obtained evidence is admissible in court of law. But here we don't know which evidences are going to be provided and which evidences are brought to the scene. So we are not clear on that thing. So I think these should not be admissible. Maybe the evidence which was lying there before the murder of Aisha was lying in that house itself, and it returns back after 10 or 15 days. That should not be admissible. It was not there at the time of murder. So I think this also should not be admissible over here.
So under which provision can you stop it from being admitted in the court?
There was a case Natwarlal Damodar Das Soni, and
I'm asking the provision.
Yeah, evidence can, ma'am, only given if it has been given by examined.
We're not able to hear you.
Ma'am, under section 65 of Evidence Act, evidence may be given as a general result of documents by a person who has examined them and who is a skilled examination of such documents. But
we are not talking about documents over here, counsel. We are talking about evidence. We are not on the point of documents. There's nothing documentary evidence.
Here we're talking about evidence stolen. That we in this proposition, it has not been mentioned any document evidence has been stolen or not. It has not given, so we cannot comment on that thing.
No, I think you're getting it wrong. If I'm not wrong, Mayuri ma'am, you mean that under which section will you say that this is admissible or it's not admissible?
Yes, that was my question. I'm asking in the law provision.
She wants a specific provision for this. Are you able to answer it right now?
Ma'am, under 65A and 65B of Indian Evidence Act.
Can you just state what is 65A and 65B?
65A gives clarity on admissibility of electronic recorders evidence.
So,
and 65B gives the procedure to how to admit it.
But here we are talking about Aditi's admissibility on evidence and not on the electronic
we are
device.
at the point of stolen evidence.
Stolen, ma'am.
Okay, stolen evidence.
When you talk about 65B, you give a certificate for that evidence.
Yes, ma'am.
In the court of law, which is a supporting document.
Yes, ma'am.
Stating that the person who has retrieved that electronic evidence is adhering to the statement and the content of that particular evidence. That is the purpose of 65. What I am asking is, how can you define, neglify, or kind of admit that evidence or stolen evidence in the court of law? That is my question. So you're getting it differently. What I'm asking is a different question.
Ma'am, I got it. Ma'am, sorry, ma'am. Got it.
1 minute left.
Ma'am, I can come back to you on this. Thank you.
Good morning, ma'am. Good morning, ma'am. Hello, good morning, ma'am.
Yeah, good morning.
Point number 4. Whether Dr. Rasim and Yash can be subjected to narco analysis. The Supreme Court had ruled that narco analysis, brain mapping, and a polygraph test cannot be conducted on any person without his or her consent. The Apex Court has noted in response to the petitions questioning the validity of such tests are illegal and a violation of personal liberty. So, narco tests can only be tried against the persons of grave danger to the society. Fifth point, whether Dr. Rasim can be charged under section 316 IPC. According to IPC 316,
So
316.
coming back to this third question, or first question, which you just narrated now,
What?
that narco analysis is allowed only in the case of grave nature of
Grave nature or
offenses.
danger.
Grave nature of danger to the society.
Dangerous to society. Okay, so here the cases that the person has tried to drive, not really, he has killed his wife, his own wife, and also a unborn child. And also, there was a possibility that he could have killed the small girl, that Aditi, who was present in the house. So, is this not falling into the criteria of being a grave offense?
Hello, madam. Which is your question? Hello, excuse me, ma'am. Hello.
Yeah, I can hear you.
I cannot hear this question. Please tell us me. Cannot hear because
I said he is already, the kind of crime that he has committed is already a grave in nature. He has killed his wife, he's killed his unborn child, and there was a possibility that he could have killed the small girl Aditi, who was present in the house as well. So doesn't that fall into the nature of being a grave offense?
that is not fall under grave offense, but that is danger to the society.
That is what I'm saying. Is that person not dangerous to society? Because then there is a proposition that he has again fallen in some affair. So that can be reiterating effect for him. He can continue this kind of conduct on each and every person that he meets.
No, ma'am.
Can I answer this?
Yeah, okay.
Ma'am, first of all, he is not a regular culprit or he has not offended, and we have not still yet to prove that he has done this job. He is in view that he is ready for the narco analysis, because as per Supreme Court guidelines, narco analysis are not meant for everybody. Because requisites of narco analysis, as you asked, first you need a consent from the parties. No compulsion or force should be there on the accused. So the statements given by the accused cannot be treated as evidence over here.
Okay.
And plus, narco analysis is only meant for terrorists, serial offenders, rapists, who are doing this job again and again. And even in this Supreme Court has observed that after multiple of narco analysis are done on a person who is doing such crimes regularly, he has turned his mind in such a situation that he cannot change the answers without changing the polygraph test. Such people can with the will, they can give wrong answers which are good enough for the telegraphic tests.
Okay.
Fifth one, sir. Ma'am, whether Rasim can be charged under the section 316 IPC. So according to the IPC 316, causing death of the quick unborn child by act amounting to culpable homicide. Dr. Rasim cannot be tried under the section 316 IPC as there is no evidence that he has not murdered his wife in cold blood, nor any evidence has been found against him. Next point number 6. Is it a fit case where the court should add a charge under section 302 IPC and try the accused person for that charge as well? So, prima facie, it looks like Dr. Rasim killed his wife Aisha Yadav in the heat of argument. However, there is no evidence to prove the same. There is no eyewitness or any other evidence. The mobile phone was also locked and evidence expired as it is beyond the 7 days to retrieve recording. So hence the case cannot be tried under the section 302 IPC. So there are relevant case laws where court have not held the husband guilty of such offences only on the basis of the prima facie incidents on where death is caused due to the sudden provocation due to the heat of argument.
But counsel, I would just like to ask, what is the preliminary section which have been invoked?
Preliminary sections invoked are 300, 302,
Yeah,
300,
302 is not invoked preliminary.
uh,
Question
300.
over here is that can 302 be invoked?
Okay, ma'am. 300, 316 and 325 of
Yeah,
the
so
IPC.
Yeah, when 300 is already invoked, what is the difference between 300 and 302?
The only difference is on punishment. 302 speaks of punishment and 300
Yeah,
speaks of
so when
murder.
300 is already invoked, 302 comes along with it.
But it has to be proved, no, ma'am. It has not been proved. Murder has taken place,
Any section.
but the culprit has not been found. Unless and
Exactly,
until
but
the
any section, when it is invoked, there is an implying effect that the punishment will be following it. It is not only that they'll declare the offense and then leave you away. Punishment will be following
Yes,
it by default. So there is no difference in 300 being invoked or 302 being invoked. That is a additional along with it that has to be with it.
yes, ma'am.
So what is your take on the last issue that your co-counsel has addressed now?
We would plead not to be guilty as the accused has not been found guilty of commission of such offences, nor has anyone seen him do so, and the trial court should consider the same. There are no evidence to prove the accused has killed his wife, Aisha.
Okay, counsel, come to this point of the postmortem report. Come to the postmortem report of Aisha.
Postmortem.
Yeah, can you just read the time of death?
Time of death approximately between 4 a.m. and 8 a.m. of 12th May 2020.
Okay, and what does the viscera report says?
No food matter was found. Some quantity of tea and water was present.
Okay, so can I propose it this way, or can I put it this way in front of you, that she must have woke up when Mr. Rasim woke up. They
1
must
minute
have had,
left.
they must have had tea with each other, and then this offense has been done. Because the viscera report, if it is seen, possibility of tea she did not had at night. It was only in the morning that she had it.
If she would have been murdered at 4 a.m., she must have taken tea at 3:30 itself then. But I don't think that.
Yes, so see, what I'm proposing is the only person with whom she can have tea from 4 to 8 is Mr. Asim only.
Or maybe she can have her own with her own self by getting up early in the morning and taking up the tea.
Okay.
May not Rasim must have not joined her.
That is a possibility that you are saying. But the only person present capable of killing her in the house was only Rasim.
But she has died of hanging herself.
Will a pregnant lady can
Time up.
stand up and hang herself?
In heat of argument, if in the heat of argument, people do not consider what is living inside them also. So maybe in the heat of rage or in the anger or in depression, she might have done so. But the depression or the anger which she has done so, we are yet to found it. We have not found it till yet.
It is to be informed that the cross-examination of witnesses should be started.
Here the first witness we can consider as Yash. And Yash has barged into the house. He has already given that his statement that he wanted his safety of his daughter. He was
It is
concerned
to
for
be
his,
noted that in the witness list, only Palak Gujjar, the investigating officer, the medical examiner, and the Aditi are present.
okay, ma'am. As we said earlier, that Aditi is not admissible from the evidences what we have looked into. We think Aditi should not be admissible. As per the officer, Mr. Gujjar, he has found, as per the police verification, whoever dies in someone's house, they catch them first. It was Rasim Khan's own house where she had died. So Rasim Khan was in the picture and he was caught. Yash being a friend of Rasim Khan, Aisha, he had just barged into the house, so there was no point in making him as a culprit.
Counsel, we are on the point of whom do you want to testify over here? It is not who you want to eliminate. You come to the main point. Who do you want to testify over here? Whom do you want to cross-examine?
Ma'am, Gujjar itself. Because he has put the case against Rasim Khan without any.
It is to be noted that Yash Gujjar is not in the witness list. Palak Gujjar is there.
The wife is there.
Palak Gujjar. Palak Gujjar. Palak Gujjar is, ma'am, his wife.
Yeah.
Yash Gujjar's wife is Palak Gujjar. She was not in the scene itself. Here,
Yash. In the witness list, that is what the situation is.
And I don't consider her also in the witness list.
Counsel, you come to the point whom do you want to consider and ask questions?
Do you want to cross-examine or you don't want to cross-examine?
Ma'am, we don't want to cross-examine.
It is to be noted if the witnesses are not cross-examined, then the 5 minutes which are given for the cross-examination would be eliminated and it cannot be continued in any further arguments.
Okay.
The time for the rebuttal, that is 2 minutes, would be starting now.
Whatever the sections have been laid on my client, we don't agree to it. As the accused has not been found guilty of any such commission of such offense, nor he has been seen by anyone do so, and the trial court should consider the same. There are no evidence to prove the accused has killed his wife Aisha Yadav. Also, the accused be allowed to plead since he has lost his loved one. He is the only sole survivor. He has not come out of the shock since then and suffering from depression. So that the accused since has become an insane, and the conviction of the accused by the Honorable Court, City of Bombay, State of India, be set aside by the Honorable Court in the light of confirmation of disturbed mental state of the accused. That the accused acquitted on the grounds of insanity of the mind. The accused is to be dealt with humanity and shown mercy in the light of fragile state of his mind. That is, the fine levied upon the accused may impugnated judgment of the trial court be withdrawn in the light of inability to pay the sum on the grounds of his mentally unfit and being unemployed now. That his honorable court may be pleased to direct the state to rehabilitate the accused as per the existing practices and norms for the person suffering from such mental ailments. The honorable court may be pleased to direct the state to inquire the foul play and investigate the original culprit for the original culprit. This honorable court may also pass such an order in the interest of the justice as the honorable court may deem fit. The court has always stated one of the basic principles of the criminal justice system is that the benefit of doubt must always be extended in the favor of accused. Thousands culprits can escape, but one innocent should not be punished. With this, I rest my case, ma'am.
Time up.
As the oral submissions of both the teams are done, I kindly request both the teams to leave.
Thank you, ma'am. With your permission.
Lady steps can have 5 minutes break. Thank you.
तेरा नेट लैग नहीं कर रहा ना अबे तो उसमें गई है
Your ladyship, now that both the teams are present, may we start with the competition?
Yes.
Much obliged, your ladyship. So we hereby start the competition. VTM 05 may please proceed with their arguments. VTM 05, can you please switch on your video and start your arguments?
Council seeks the permission to approach the dais.
Yes.
Much obliged. May it please the court, I am the appellant on behalf of the state on the jurisdiction of Honorable Section Court. May I proceed with the facts or may I continue with the issues?
Start with the issues only.
Okay. So I would like to present my issue number 1, whether evidence from Aisha Yadav's second mobile phone is admissible in a court of law. Yes, under section 65A and 65B were added in the Evidence Act in 2000, which talk about the admissibility of the electronic evidence in the court of law. According to section 136 of the Indian Evidence Act, when either party proposes to give evidence of any fact, the judge may ask to any fact, the judge may ask the party proposing to give the permission to give the evidence in what manner the alleged fact is proved. Would he, which Aditi has submitted to the police authority, is straight relevant to the case because the second mobile phone has having some special features which records the conversation between 10 a.m. to 5 p.m. It can be a strong evidence against the accused. May I proceed with the issue number 3, ma'am? Much obliged. Whether evidence stolen from the crime scene is admissible in a court of law. The facts mentioned in the case fails to give any idea about the evidence stolen from the crime scene. On the day when its incident took place, police authorities has inspected the crime scene and collected every possible evidence from the along with Aisha's mobile phone. From the day before the incident took place, the second phone was with Aditi. As per the known facts, so the mobile phone given by the Aditi as an evidence is not at all stolen evidence. And if we consider the Aisha's second mobile as stolen evidence, then admissibility means that only the facts which are relevant are admissible in the court of law. Section 136 of EIA 1872 explains which all evidence is admissible. Section 136 states that it is the discretion of the judge to decide whether the evidence is admissible in the court or not. May I proceed with the issue number 4, ma'am?
Yeah.
Whether Dr. Rasim can be charged under section 316 of the Indian Penal Code. Yes, Dr. Rasim Khan was from the starting of his wife's pregnancy asking her to terminate the pregnancy because the doctor's affair were also there and he was having zero interest in the relationship. And when Aisha refused about, and when Aisha refused that she will not terminate this terminate the pregnancy, he started accusing Aisha of infidelity and
Counsel, that is all a prehistoric statement which you're saying prior to the death or prior to the incident, day of incident. The
Yes,
point of prosecution should be on what grounds, on what evidences are you trying to help Mr. Asim in this particular offense? Is there any direct evidence to his record against him?
Yes, ma'am, I'll come to that point. As per the section 316 of Indian Penal Code, which talks about the causing death of quick unborn child, that person was already knowing that she was pregnant. And it is already all evidence are going against the accused because
What are the evidences? That is my question. What are the evidences against him?
ma'am, the post-mortem report, ma'am, which it has mentioned that the wrist fractured, the neck bone has broken. We can assume that
You can't
after-
assume, counsel. You can't assume. Law doesn't work on assuming. I'm asking about what are the evidences against Mr. Rasim. The postmortem reports, what you're stating is very, very correct, very true. What are the direct evidences to show that this wrist fracture, the hanging, everything has been done by this person, that is Mr. Asim Khan?
Ma'am, the accused was only the person who was staying with her, and there are the more possibilities that in the morning after in the postmortem it has mentioned that they had tea and half water also. Rasim was the last. Rasim was the last one to leave the home. So,
What is the time of death as per postmortem report?
ma'am, as per the postmortem report, 4 to 8 p.m. The assumption.
What time did Mr. Asim leave the house?
Sorry, my lordship.
What time did Mr. Asim leave house?
7 a.m.
So there was one hour wherein Mr. Asim was not there in the house.
Sorry.
There was a time from 7 a.m. to 8 a.m. during which Mr. Asim was not in the house.
Ma'am, but at that time no one was there in the house. The only
That
girl.
is my question. There was no one in the house. Then how can you put this contention across that Mr. Asim was only killed and he went away?
Because Rasim was not wanting this relationship, ma'am.
He had only called his wife and Mr. Yash and Aditi the earlier day for dinner.
Yes, but he is the only one who asked her to stay because it was a pre-planned. He called her giving the false reason that her parents will come and he want to resolve, but the parents will not. It is not at all the coincidence. It was already planned to commit the offense. And
Is there any planning evidence to that record? See, any person who is kind of planning or plotting any kind of offense to happen has a history of any kind of communication or any kind of evidence for his planning also. So is there any evidence that he's planned it in prior before this lady came to his house?
and there is an intention to kill because violation and assaulting her. She from the in previous time also when they were both were together, he was assaulting her. Occasionally he was assaulting her in the arguments of the when the external affair was coming between. He was assaulting her.
Is there any complaint made by your client, made by the victim to that effect?
No, ma'am.
Then
anything that she's proven to say that these assaults were on a regular basis?
It is a no fact, ma'am.
No, but like
One minute,
as the leadership has asked you, that did you have anything to prove that these assaults were regularly happening? Had she reported these assaults to the police station, or she had filed any kind of a complaint
Speak louder.
during the physical assaults that you've been submitting? Was there anything like a DV filed in the court or anything of that had happened? Had your client filed anything in the court or had made a complaint at the police station?
No, ma'am. No, madam. Assault was the reason to leave the marital home. She may be expecting that fact after some days or after some months he will get better, and the reason that was the only reason she came back to resolve everything.
time up.
Ma'am, audio.
Yeah, you're audible.
Coming to the section 6,
You
it
are
is
only going to present the second propositions also remaining.
with the respondent.
Are you only going to put forth the other points, or is there any mooter number 2 also in your group?
Is there, ma'am, but one issue is remaining. Can I skip that or I should continue?
Let him
Your time is up.
let him continue it.
Council, may I seek permission to approach the guys? Much obliged, Council. I'll proceed with the issues.
Please be a bit louder. You're not audible clearly.
Lordship, issue number 2, in which Aditi, whose statements has to be considered. According to section 1.8 of the Evidence Act, it is stated that any person who is deemed fit can be considered according to the court. If permitted, his statement can be considered in the court.
What is
Now-
the law regarding, Council, what is the law regarding the statement to be given by a minor?
According to this, the section which I have, ma'am, and as well as this minor, he's 10 years old. Aditi is 10 years old, but she is not. There is no medical history proving that she is not able to understand or having psychotic.
My question is, what is the law regarding the statements to be deposed by a minor in a court of law?
Uh,
Legal provisions.
I will, Council, I will come to this issue a little later. I will definitely make a get back on this point. May I further proceed with this argument? Much obliged. For the statement, which for this particular issue, I would request Council to please consider that the child is the witness, one of the witness amongst the three who has seen that Rasim Khan, who was the main accused in this, must have committed the crime. And if the witness or the statement of the child is taken, then we'll be able to diagnose further about this issue. Or may I proceed with the next issue, my lordship?
What I'm stating is the girl was sleeping in the adjacent room. There was nothing which she was frightened. She has seen anything that she primarily stated to her father also.
Ma'am, there is no statement that she has stated some regarding told her father or had a conversation. It is mentioned that during the police interrogation, she has produced another phone, as well as when during the statement she was able to provide the statement. But after that, it could be a possibility that something might her statements might have changed, but during the time of the interrogation, when the police asked, the statements were different. So the child, after the child aware, the child was fast asleep, this statement could have been manipulated. But but Aditi was aware. She was emotionally attached to Aisha. She knew about the her statement should be considered, my lordship.
What were the injuries which were inflicted on Miss Aisha?
The injuries to Aisha were on the wrist, on the neck, on the face, and it was a blunt injury. And this injury which had happened is not only from suffocation, also there's a U cut on her neck. So if it's a suicide, it should be a V cut.
Which cut is that?
The neck of innocent Aisha.
No, which injuries you said?
There is a.
Can you read the injuries which is mentioned in the postmortem report?
My lordship. I request you.
Also, I have a question to ask. You said it was a planned way of injuring her, but how can you prove that it was planned?
Yes, my lordship, it's a planned murder. Aisha, who was ready to come to Rasim to solve her marital problems, she was told, he was under the impression that Rasim's parents will be there. That is the reason why Yash and Aditi accompanied her. She wanted to resolve the issue in hopes that her marital problems could be solved. But Aisha was not aware that Rasim had some cruel intentions. Also, there's a previous history of assault because Rasim did not want the child. Uh, the fetus, according to the postmortem report, is 24 weeks. If we look the postmortem further, a 24 weeks fetus is uh, is like another person. So it's not just one innocent person, Aisha, who has been murdered, but also an unborn child.
Counsel, my
And
question, I'm just pulling you back to the question. What are the injuries which you said are inflicted on Miss Aisha, which you say that it points out that the murder has taken place? It can also be a suicide.
my lordship, there is a deep laceration around the neck.
What do you mean by laceration?
Laceration is like a cut which happens on your neck. So you need some kind of a weapon.
Laceration happens technically only by a weapon.
It could also happen by a rope which is forcefully put on the victim, and it has to be with brutal force, but it should not be like through like one angle. It should be from two angles, two different angles.
And what do you mean by hyoid fractures?
The fracture on the wrist, it's like a breaking of the bone.
No, the last fracture which is present with the saying hyoid fractures.
Hydro fractures.
Hyoid fractures.
I apologize, my lordship. Hyoid fracture is a U-shaped fracture. So
it's not a U-shaped fracture. It is the fracture of a bone.
Fracture of the bone. Fracture of the.
1 minute left.
Yeah, continue with that. What you stating?
Once the fracture has happened, the tongue might be might come out. The bone of the tongue is there's a bone below the tongue. That bone is fractured, and it is that bone has that tongue is attached to the.
Exactly. So that can happen only when a person is hanging him or her through a rope. That cannot happen by strangulation.
My lordship, it is not possible for him to first strangulate with the strangulate. He might have killed her by deep laceration. Then he might have
1.5 inches of laceration will not kill a person, counsel.
But my lordship, it's before.
Time up.
My lordship, it's not. I understand it, my lordship. He has first murdered and then he has framed in the form of a suicide by putting my client on a fan. My lordship.
Yeah,
It is to be noted that the timings for the cross-examination of the witnesses has started. So you can call any witness if you want.
Start with the cross-examination.
Cross-examination witness. Okay. I would like my learned my counsel to proceed with this. My lordship. Computer one. Yes, my lordship.
Yeah, start. Please start with the cross-examination, counsel.
Ma'am, in issue number 6, it is a fit case.
We are on
Whether
the point of cross-examination, counsel, not on the point of issues now. Whom do you want to cross-examine? Just ask what is the list of the cross-examination witnesses. You can ask the court clerk what is the list of cross-examination
what is the list of the cross examination?
witnesses for the cross-examination. You can just understand. Are you aware of who are present?
Yes, yes, my lordship.
Do you want to cross-examine?
Ma'am, I like to cross-examine the Yash because
Yash
he
is
has-
not available in the witness list.
Are you aware of the list of witnesses for cross-examination?
no, my lordship.
Court clerk may please address them. Who are the list of witnesses for the cross-examination?
My ladyship,
Yes,
I
your
think they
ladyship.
don't want to address. They are not aware who are the witnesses for cross-examination.
Your ladyship, the participants were made aware about the list of the witnesses, but to still reiterate who are the witnesses present today, Aditi, Palak Gujjar, the investigating officer, and the medical examiner are present. Any of them can be cross-examined in this 5 minutes.
Palak Gujjar and
Palak Gujjar, Aditi, investigating officer, and medical examiner.
okay. Medical examiner.
Do you want to cross-examination, counsel, or you want to just leave?
Yes, I want to cross-examination the medical and the Aditi.
Yeah, then start, please.
I want to ask
You're going to cross-examine Aditi.
1 minute left.
Aditi haven't heard any voice from the next room because if if she can hear
You
the
have to ask question. She witness is there in front of you. You have to ask question. You just can't kind of, give theory. Can you see the witness? She's present in the witness box.
yes, now I can see. Did Aditi heard any voice?
Hello.
Hello. Have you heard any
Aditi
voice?
here.
Can you hear me?
Hello. Aditi here. Aditi is there.
Aditi, I want to ask you, did you hear any voice that day?
No, I was asleep.
Sorry?
No, I was asleep.
You were asleep.
Sorry.
Can you hear me? Hello.
She said
Yes.
she was asleep. She did not hear anything.
Okay. Wanted to ask.
Time up.
Okay. May I proceed?
No.
It is to be noted that the next 2 minutes start for the rebuttal round.
Am I audible?
Yes.
My lordship, I want to ask a question that why didn't you give your second phone when the
Your
investigation was going?
cross-examination is over, counsel. You have to start with your rebuttal now.
Sorry, ma'am.
Your time frame for cross-examination, the time provided to you is over. So now you have only 2 minutes left for rebuttal.
For?
Rebuttal.
I want to ask Dr. Rasim why he have denied the
Your
denied
time for cross-examination is over, counsel. Start with the rebuttal points. That is, you have to explain in just what line of arguments you want to proceed now. Witness is over. You have wasted much of your time in that.
Can you rebuttal round my co-counsel can appear here?
I think you're hardly left with a minute now for rebuttal. Can you just quickly complete your arguments?
Time.
Is the co-counsel coming or not?
My lordship, I apologize. My lordship, may I have the permission to proceed? My lordship, I have rebuttal regarding the with the accused. So Yash and Rasim Khan has committed a crime, but he has is Rasim Khan if he did from our side we think that Rasim Khan planned the murder, and our rebuttal is why did Rasim Khan not murder the child? If he wanted to kill Aditi, he could have proceeded with it. He had motive. He had clear motive that during that time in the room and Aditi was there. He wanted to during that time, which is 4 a.m. to 8 a.m. in the night when Aditi is a child could definitely be fast asleep. He decided to murder, and this is the reason he planned that after murdering her, he went to his office and he yes.
Time up. VTM 06 kindly start. Thank you.
Your Ladyship, with your new permission, can I start the jurisdiction of the case?
Yes.
The Honorable Court has jurisdiction to try the instant matter under Section 177, read with Section 209 of the Code of Criminal Procedure, 1973. Section 177 states that ordinary place of inquiry and trial, every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Read with Section 209, commitment of case to court of session which offence is triable exclusively by it. When in a case instituted on a police report or otherwise the accused appears or is brought before the magistrate, and it appears to the magistrate that the offence is triable exclusively by the court of session. Firstly, he shall commit the case to the court of session. Second, subject to the provisions of this code relating to bail, remand the accused to custody during and until the conclusion of the trial.
Counsel, come to the point of issues. What are your issues in this matter? We are not on the point of jurisdiction. It is a case before the trial court only. You come to the point of arguments.
Okay. Shall I proceed? Thank you. Whether the evidence from Aisha Yadav's second mobile phone is admissible in court of law. Yes, under section 65A and 65B were added in the Evidence Act in 2000, but here the evidence holds no true since the mobile was with Aditi and she slept in the guest room and Aisha was found dead in the bedroom. Second issue, whether the statement made by Aditi is admissible in the court of law. Section 118 of the Indian Evidence Act determines.
Counsel, you just start with your points of argument, so it is okay.
Oh, okay. That's object. Just a second. My co-counsel would like to continue. May I proceed further, leadership, with due permission? Much obliged. The opposition stated that there were marks in the body present where when the body was taken for the taken to the hospital. But as mentioned, there is not such any cases that the assault that were done towards Aisha were on the regular basis, or there is no noticeably anyone can give the evidence that there were common fights between them, rifts between them, and exaltation against them. And yes, the evidence talking about the phone through section 65A and 65B of the Evidence Act, we can state that the evidence in the second phone can be admissible in the court of law. Further coming to whether the statement of Aditi is admissible in the court of law, yes, it is admissible through the section 118 of the Indian Evidence Act. In the landmark cases like S.M. Amita versus C. Manivana Bupatti, 2007, laid down that testimony from a 10-year-old, the evidence of a child witness, and credibility, therefore, would be depend upon the circumstances of each case. So here it is clear that the statement by Aditi is admissible in the court of law. Further moving on to whether Rashmi can be charged under the section 316 of IPC. So according to IPC 316, causing death of quick unborn child by amounting to culpable homicide. But it is not, there is no such evidence present that he has murdered her wife and he doesn't want that child, and so I would request that these allegations made on my accused are false, and I will here end my argument.
But counsel, the section 316 is invoked on the prehistoric line of incident which has taken place between the victim and your client, that is accused, that is Rasim Khan. So in such situation, can't it be justified for the prosecution to take a doubt or suspicion on him?
But ma'am, the opposition says that there were assaults, but no such complaints are registered on my accused that there was a regular basis assault on him, or he was having.
Also, are you aware of the last seen theory?
Sorry.
Are you aware of a theory called last seen theory, which is used in criminal law?
Sorry, Lordship, I'm not aware of that.
So technically, if you are seen last with the person who has died, it has an implying effect that, or a strong suspicion can be created that it is the person who was last seen with the victim has committed the crime of murder. So what is your take on this
No,
last scene theory?
no, ma'am. According to the medical reports that we have got from the medical examiner, the time of the incident that took place, it is between 4 a.m. to 8 a.m. And my accused has left the home at 7 a.m. So there is a time of 1 hour duration. And when Yash visited the house and he was asked how he entered the house because the house was locked from inside, right? So how did he enter inside the house?
So
And he
counsel,
entered the
when
house
you
and
have a report of postmortem, the time frame of 4 hours is given.
yes,
Exactly. So if it would have happened from 7 a.m. to 8 a.m., the time frame given by the postmortem will be 6 a.m. to 10 a.m., which is not the case.
yes, my
Time
leadership,
frame
but
over here is 4 a.m. to 8 a.m., which is roughly 3 hours in your bucket, wherein 3 hours you were there with the victim.
yes, my leadership, I agree to that fact. But still, I think that the allegation made on my accused are not on point because he want to resolve the matter, and for resolving the matter with her wife, he invited her for a dinner and wanted to resolve the matter. So he also uh, wanted that the common friend also visited them.
The very pretext why your client has called was a false pretext. He had called
Yes.
her under the pretext of that his parents were going to visit, which is not the case. And had it been that Miss Aisha had visited his house alone the previous night only, this murder could have happened the previous night. The only thing was Mr. Yash and Aditi also visited the house along with her. That was the reason he couldn't find her alone.
But ma'am, stating that you told that the time between given is 4 to 8. There is also a fallacy present in the postmortem report. That is, the age of Rashim is according to the year is 1977. That is 45 years. And the age of Aisha Yadav.
Pardon me, I just couldn't hear. Your voice is it is humming in between. Just repeat what you said.
Sorry, my lordship. I would further say that the postmortem report also have a fallacy. That is, Razin Khan's age is, according to the year 1977, that is stated in the proposition, is 45 years. And in the proposition, it is also stated that, according to the year 1984, the age of Aisha Yadav is 38 years. And in the postmortem report, it is mentioned that the age is 35 years. So there is a negligence of the age in the postmortem report.
How does
So
that
therefore,
matter? How does that matter, counsel? The person has died is a fact. His age may be 35 or 45 or 65. The fact that the person has died is died. How does the age matters? Even if it is 3 plus 5 or 35 or 38, you can't have any kind of displacement to it. There's nothing to oppose that proposition. The fact is enough for it.
but ma'am, I would further begin with my statement that only that if there is a negligence and a possibility that they have changed the year of the age, there can be a possibility that the time duration might also be have some issues in it. If there is a fallacy, ma'am, it can be.
Do you deny about the fact that she has died?
No, I won't deny the fact that she has died.
Okay. Do you know what is a concept called biological age?
Yes.
Can that be a possibility in this case?
Yes, it might be, but again, sorry, lordship, ladyship, but I will still stick to my point that there is a fallacy, and it can be the possibility because the opposition is making fake allegations on my accused that he has planned the murder. He wanted to do this with her unborn child and her wife. But I will state that the accused don't want to do that, and for this only he wanted to solve the rifts there were between them, and for the resolution only he has invited her.
Yeah, but if we go by the last scene theory, your client was the only person who had been seen with the victim when she was last alive. That is the only thing. And the very fact that, can you just come to the injuries part?
Yes, ma'am. I can definitely uh, I can definitely talk about the postmortem report.
No, only about the
It is
injuries
about
first.
the what? Sorry, what?
Injuries part.
Injuries were deflagration around the neck, that is 1.5 wide,
How does that
and fractured wrist.
Counsel, how does that take place?
As the body was hanging, so there is a possibility that there would be a mark near his neck, near her neck.
What do you mean by laceration? Deep laceration.
I would, according to my knowledge, leadership, I think there might be a cut near her neck.
No, I don't know. I'm asking you. What do you mean by laceration?
Sorry, leadership. According to my knowledge, all I know that I think that there might be a cut around her neck.
Okay. Is there any weapon found?
No, there is no evidence found from the crime scene.
You come to the next injury.
The next injury is the fracture wrist of the left hand. It is a possibility that the ball, while hanging herself or dragging, there might be a fracture in her hand, wrist. Sorry.
So you want to say that the victim has herself hanged her? That is what you
No. No, I won't say that it is a case of suicide, ladies.
Then what is the case? What is your case?
But there can be possibility of suicide. I'm not stating about sorry, ladies, but I won't state about the matter as a suicide or as a not whole as a suicide, but there can be a possibility. As my accused was not present there.
What about the last fracture? And the injury on right side of face?
Right side. There must be a possibility that when a murderer might threaten her, she has got a word. Your leadership, I will continue that while her body was hanging, there might be a pressure on her body.
You're not audible, counsel.
Am I audible?
It's humming sound actually. Can you just remove the earphones and just use the device? You can remove the earphones and try. Disconnect it from the device and use.
Yes, ma'am. Am I audible?
Yeah, you're audible.
So I would state that when her body was hanging, there might be a pressure which could lead to the neck bone fracture.
Is there a possibility in that way?
Sorry, Lecha.
Is there a possibility in that way?
Yes, there might be a possibility. I agree to that.
Okay, there's also a condition wherein there were several wound marks on her body. Several wound marks. Will that happen that she'll hit herself first and then get killed?
No.
Then what about that? Because the postmortem report as well as the fact sheet says that there were several wound marks.
Ma'am, I would like to add a point that when after the incident took place, when Yash entered the house and he got to know about the incident that took place, after the investigating officer asked him the question about how he entered the house, he was not able to answer that. So there is a lag bit there also. There is a lag present there also. Why he was not able to justify how he entered the house. And as the postmortem report
But
states,
before
there is a difference of
entering the
time.
house, before entering the house, Counsel Yash has made a call to Mr. Asim.
Yes, there is a possibility he might be calling him to ask whether they have woke up or he can come to pick up them. But Rashim didn't pick his first call. So he further went to the house, and then there he came to know about the incident. Then he further tried to call Rasim, and then after that, when he get inside the house, he then directly called to the police.
So what is in fault over here?
Sorry, Lechip.
What is the problem that you see in the situation?
The problem that I find is why there is no evidence, first of all, present in the crime scene, which can relate to a cut near her neck. And Yash would have forced kill her because of her wounds that occurred to her. Because Yash was not able to clarify how he entered the house. So I would say that my accused.
That is immaterial, Counsel. I mean, he entered the house, he barged into the house, he broke the door open. The fact that she was hanging is a fact that before he entered the house and when, at the time when she entered the house, she was hanging there.
Yes, Maledition. But still, I would stick to the facts that there is no evidence present in the crime scene that could state that my accused has killed her wife. And I would still continue that he want to resolve the matters between them. So I don't see a possibility, and I see that the opposition is just making fake allegations against my accused. Hence, they cannot prove the murder. So they want that there is a negligence from their side, and they are proving that my accused is the murder.
Time up.
Shall I begin with my cross-examination, ma'am? So first, I would like to call the medical examiner with your due permission, leadership. Sir, would you please introduce yourself to the court? You are not. Your voice is not audible. Can you tell the experience of how much years you have been practicing in this medical field?
I've been working in this field for the past 25 years.
So, sir, due to your experience, it is very easy for you to tell through your expertise that how the murder took place, what is the timing, what is the exact timing according to you, or what kinds of wounds you find that could state that it was a pre-planned murder or a murder.
Firstly, I would like to tell that I can't state it's a murder or suicide. And secondly, the injuries found were deep laceration around neck, which was 45, and she had hairline fracture on her left wrist and bruise on her right side of the deceased face, and her bone was fractured.
As you are not clarifying it that it is a suicide or murder, so how can you state that it is a according to the injuries that it is a clear cut?
Can you elaborate your question?
I would say that, as you stated from your first line, that you are not clear about the fact that it is a suicide or murder. So how can you state that it is a pre-planned murder and the injuries that you have
Counsel,
noticed?
you can't ask leading questions. You can't ask leading questions to the witnesses. Are you aware about that?
Sorry, my lordship.
You can't ask leading questions.
Sorry, my leadership. Did you find any assault injuries?
I just mentioned deep laceration around neck, which was 1.5 weight,
So there were no assault injuries present there.
And there was a on her left wrist, which can be due to violence or during transportation.
Okay, thank you. Your ladyship, it should be noted that the doctor himself is not ready to clarify whether it is a case of suicide or murder.
That is not his job. His job is only for the observation part. Suicide or murder has to be decided by the court.
Court.
Sorry, my ladyship. I would further like to call Palak Gujjar. Could you please introduce yourself to the court?
Myself, Palak Gujjar.
Okay. From how long do you and your husband know the deceased and her husband?
We know each other since 4 to 5 years.
Just 4 to 5 years?
Yes.
Okay. So how did you guys met often?
We met
Answer
during
your
parties
language.
and then our language.
Did you know about the fact that there were rifts between Rashim Khan and her wife?
Yes.
Are these assault on the daily basis?
No.
No. Okay. If you think that Rashim behavior was not good, then how could you send your 10-year-old daughter to her house?
Counsel, don't ask leading questions. You're putting the thing in her mouth. She never said Rasim was good or bad. She did not testify his character. Don't put your words in her mouth. Ask plain questions to her.
Sorry, my ladyship. So, how was Rasim's behavior towards you and your daughter and your husband?
He was one of our close friends and he was very nice to us.
Okay, thank you. Much obliged, ladyship. I would further like to call Aditi for the witness.
Time up.
It is informed to the team that the time for the cross-examination has ended and the 2 minutes for the rebuttal starts now.
Okay. Your ladyship, with your due permission, I would request that my counsel will proceed with the further proceedings. Much obliged.
Your Ladyship, I would like to continue the rebuttal. As the accusations were given by the opposition that it was a pre-planned murder, but there are no evidences found. So according to the prosecutor, that they were so assured and they were facting that Rasim Khan has only done the murder and there are no other facts that could possibly lead to other things. And there is no evidence to it. Also, if they are claiming that Rasim was so assault and he was so violent, then why didn't he not harm Aditi while she was being at home? And I would just simply say that they are simply giving fake allegations
to the accused and not accepting the fact that he is not the murderer and simply giving false claims to it. Even the medical examiner was not sure if there has been regular assaults.
Time up.
To the
Your ladyships, now that the competition has ended between the VTM 05 and VTM 06, we'll take a break of another 5 minutes and we'll move ahead with the other two teams.
Okay.
Much obliged, your ladyship. I request the VTM 05 and VTM 06 to kindly leave the meeting.
I just wanted to confirm whether we are audible.
Yes, you are audible.
Thank you. ऊपर है 40.
PTE 07, kindly inform me if you are a participant of VidhiTaksh 2023. PTE 07, please rename yourself with your team code. Your ladyships, with your permission, may we go ahead with the competition?
Yes, we can start.
Your ladyship, may I seek, the council seeks permission to approach the dais. Thank you. Much obliged, your ladyship. The council seeks permission to interpretation. Your ladyship, I'm the council and my co-counsel. My co-counsel will be leading with. I'm the counsel who is Mooter 1 and my co-counsel is Mooter 2. I will be leading with the issues 2, 4 and 6 and my co-counsel will be leading with the issues of 1, 3 and 5. May I proceed, your ladyship? Firstly, to bring to your notice, your ladyship, the defense has the defense has portrayed portrayed the name of the police station and some additional information which is not given in the proposition itself, and which is interpreted by them, which is not acceptable. Now, I would like to lead with the first issue, that is whether the statement of by Aditi is admissible in court of law or not. The council states that the statement made by Aditi is admissible by court of law because the admissibility means that only the facts which are relevant are in the court of law, which is stated under Section 136 of the Evidence Act 1872. Under Section 27 lays down that when any fact is disclosed to a discovered to as consequence received from a person accused of any office in the custody of police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. Your ladyship, according to the Supreme Court, according to the case that we have stated, that is Suresh versus the state of UP, the Supreme Court in the case held that the testimony of a 5-year-old is admissible as the girl could comprehend and understand the question. The court also said as long as the child is able to comprehend and understand the question, their testimony. Here, Aditi is the witness, a 10-year-old girl, and is mature enough to understand the circumstances.
What is she witness to?
Pardon?
What is she witness to?
Sorry, your ladyship, may I introduce the facts to you?
No, I am aware of the facts. I am asking you, what has she witnessed? According to you, what has she witnessed?
She has witnessed the evidence that she was present on that day when the murder took place in the house, and she also produced
the only fact that she was present in the house. That is the only statement that you can put forth. There is no statement on record that she has seen something happening.
No, your lordship, your ladyship.
Then, if she has not seen anything, if she was sleeping when Mr. Yash came back home, how can her statement matter? What is she going to depose even if she's brought on record?
In her statement, she mentioned that the deceased, that is Aisha, was after the dinner she went and she slept, and after that since that night no one came into the house. So no one came.
I'm on the point, counsel, that what can this small girl Aditi depose? According to you, what can she depose? Possibility. What possibility do you think that she can depose?
Sorry, your ladyship, your voice is not audible.
I am saying, according to you, what is the possibility that Miss Aditi, the small girl Aditi, can depose? What, according to you, you think that she is possible that she can depose?
Her statements matter because she was the only one.
Counsel, my question is, what possibly you think that Aditi can depose?
She might have heard about, she might have heard some voices, as we have seen that there were lacerations on the, so that is the possibility she can help with as the witness.
Had it been that she must have witnessed something, why would she be alive today?
Pardon, your lordship.
Go forward.
Sorry, your lordship. So as she is a minor and there is no mental disability with her and no mental sickness, and therefore whatever she says is admissible in the court as a testimony. Further, I would like to move on to the further issue, that is issue number 4. That is whether Dr. Rasim and Yash can be subjected to narcoanalysis or not. Narcoanalysis is one of forms of investigation. Some sort of statement from the accused is acquired, which might form evidence. Therefore, narcoanalysis is used to describe a diagnostic and therapeutic technique that uses psychotropic drugs, particularly barbiturates, to induce a stupor in which mental elements with strong...
Counsel, I know what is narcoanalysis. You just answer this question. Can Mr. Yash and Rasim be subjected to narcoanalysis? You just answer that question.
Yes, Your Lordship. The accused, that is Dr. Rasim and Yash, cannot be analysis, as it
cannot be. You're saying they cannot be subjected to.
Yes, they cannot be subjected.
You are from which side?
States. I'm the prosecution.
So you don't want them to be subjected to narcoanalysis?
No.
Why?
And why do you say so?
Because there are clearly there are much evidence which are against the accused, we can see, and which the accused do not want to portray, which the accused do not want to bring into the court. That is the evidence we have gotten from that recording, but he refused the recording, saying that it is invasion. Sorry, Your Lordship.
1 minute left.
Invasion of privacy, and therefore it is there are many evidences which relate that the accused must have been murdered, the deceased. Therefore, narcoanalysis is not needed right now for this stage.
Okay.
Is the ladyship satisfied?
Yeah, go for the next point.
Yeah, thank you. And as Yash has not given the consent, it is not, as Yash has not given the consent of narcoanalysis, he is not subjected to narcoanalysis in that way. And in spite of giving the consent by the accused for narcoanalysis, there has not been taken the approval of the court for the narco test. And therefore, they are not. Thank you, Lordship. My co-counsel would like to proceed.
Yeah, start.
Counsel seeks permission to approach the dais. Should I?
Yes.
Okay, so I would be first dealing with the issue number 2, which is whether the statement by Aditi is admissible in the court of law. So
already dealt with it, counsel.
No, ma'am. Okay, sorry. Whether the evidence from Aisha Yadav's second mobile phone in the court. So evidence according to the IT Act of 2000, electronic records are defined as data, records, or informations that is either sent or received or stored in any electronic form, or it might be computer generated. And since past times, IT Act has been.
Counsel, we are not on the point of definition of what is electronic evidence. We are on the point, can a stolen evidence be brought on record in the court of law?
Ma'am, I'm on issue number 1, whether the evidence of Aisha Yadav's second mobile phone is admissible in the court. So, according to me, the second mobile phone is the only evidence which contains the recording and the only proof which can tell us what happened that night. The mobile is a very crucial evidence, and under the Indian Evidence Act of 1872, it is also admissible to take it into the court. As the phone contains all the recording which was done on that night, and it's the Aditi is innocent. She is a minor. She took the phone out of her innocence. She was very close to Aisha, which is so she just took the phone for playing games. It was a purely an act of innocence, so the phone should be admissible in the court. Should I move to the next issue? Okay, so my next issue is issue number 3, which said that whether the stolen evidence is admissible in the court. So, according stolen evidence it's not particularly stolen; it is just tempered. The evidence is not destroyed, not obliterated. Aditi took the phone out of innocence. She didn't took it out of any planning and plotting. The evidence was neither not not stolen. So the recording should be admissible in the court.
But what if it is tampered in any way?
Ma'am, it's not tempered in any way as far as the facts are given.
No, but the question itself, it says, the issue itself, it says that whether a stolen evidence can be admissible in the court of law. So if any evidence is stolen, for an example, we can say if it is stolen, what is the credentials of its eligibility in the court?
Ma'am, yes, Yash also stated that he will retrieve the evidence. But if it would have been stolen, why would he seek to do so?
We are not on the point of only of the second mobile.
Okay.
We are on the point of any other evidence which is stolen from the crime scene. Did you read the issue? Just read the issue again.
Whether the stolen evidence is admissible in the court.
Exactly.
Yeah, ma'am, but
as a prosecution, are you comfortable enough with allowing evidence which has been stolen and then brought back before the prosecution? Can there not be a possibility of the evidence being tampered in any way?
Ma'am, the section 204 of IPC states that sorry, Lord Ladyship.
Start with the next issue.
My next issue is whether Dr. Asim can be charged under the section 316 of IPC. The section 316 of IP is basically killing of an unborn child, like the act which amounts to killing of an unborn child. But here Asim cannot be charged under the section 316 of IPC because the Rasim can be charged under the section.
First, make it sure you want to charge him or don't want to charge him.
Cannot be charged. Can be charged under section 316 of IPC.
Can be or should be?
Because he said Aisha that to abort the child, whereas that means he had issues with the child. So it is possible that he wanted to kill Aisha as well as the child. So he should be charged with it is an act of mania.
What is the
And
what are the requisites?
also according to the ma'am, sorry.
What are the requisites of 316?
It was key determinants like a death caused death of a quick unborn child, which is which is an act amounting to culpable homicide.
So is there any evidence to that record that he has actually killed the child?
Ma'am, it's not like according to the previous conversations which he had with Aisha, his wife, there were the relation between them was not good. Also, he said Aisha to abort the child and except him, no one was at that time.
Counsel, I'll just ask you this one question. If you're saying 316 to be inflicted on Mr. Asim Khan, why would he create such a huge evidence in his own house? Did you ever think about him? Why will he call his wife, kill her in his own house and leave that evidence on record and then walk away for him to be just being arrested by the prosecution?
Ma'am, it was not shown as suicide. It could have it was shown as suicide. It could be a murder, after which she would have been hanged on the.
On what are you sure about what you want to propose?
And he was present there between 4 a.m. to 7 a.m. and has the.
My question is, why will he leave that evidence in his own house? Even if he was present at that particular time period, he was not present at that time period. Why will he leave that in his house and go?
Ma'am, he was not aware, and it could be taken against him for his innocence. It would be taken why will he do so?
Then?
So as you are also saying, why would he leave such a big evidence at his home? So there might be a thought in his mind also that he the state or the prosecution will not take me in target such clearly, and he might not be aware about the recording.
But the recording is not brought on record only. First of all, the dead body was in his house now. Why will he leave the dead body in his house? He would have went, and if he wanted to kill her.
Ma'am, if the dead body would not be there in his house, he would be also be the direct suspect. But here he can show the case of alibi.
He could have went to the hotel where she was staying and then killed her and came back. He would have used this theory in the hotel as well. Why his own house?
To prove himself innocent, I said, to show the state that he is not the culprit. State can also have a view that why would he do at his home? If he wanted to do it, he could have done it somewhere else. And also in the records of the hotel, it would be shown that he came.
So you are also to see that she has come.
The data entry of the hotel could show that Rasim came to meet Aisha.
Yeah, but then that same theory would be applied in the hotel as well. He would have hanged her and walked away, stating that it is a suicide case.
Am I audible? Am I audible?
Yes, yes.
Ma'am, the hotel records may show that he came to meet Aisha. And also all the CCTV and all, which are present in hotel, which would not be there at his home.
But that would only show that he came and he went. That wouldn't still show that he committed the crime over there.
Your ladyship, the timings for the cross examination starts now.
Start with the cross examination.
So, Your Lordship, I would like to call upon the witness, that is Aditi. Aditi. Were you there?
What did you see?
Were you there at the crime scene?
Ma'am, are we audible? Like we are not able to see Aditi and hear her.
You're audible to me.
So we are not able to see Aditi, the witness.
Yes. What did you see?
Aditi, I would ask you, where was the Aisha auntie when you went in the room?
First, let her answer the first question.
Were you there at the crime scene that night? We cannot hear.
The witness is not audible.
You are muted, Aditi.
Hello, am I audible?
Yes.
Yeah.
Were you there at the Dr. Asam uncle's house with Aisha auntie and your father?
Yes, I was there.
And that night, what did happen?
At night, we went to Rasim uncle's place. We had dinner and Yash uncle left. Then we slept.
Yash is your father, no?
Yash, sorry. My father, Yash, left.
And then after that, what did Aisha auntie and Dr. Asim uncle do?
Aisha auntie went off to sleep.
And when you went to the sleep, where was Aisha auntie? Was she in the...
Sorry?
Did you see the... What did you see in the morning when you wake up?
In the morning, my father was there. He was making some phone calls.
Okay. And what about the body?
And then what did you do?
I have no idea. My mother came in the morning and took me.
It's very low.
Sorry?
Your mother came in the morning.
Yes. And she took me home.
And did you take the mobile that you have produced in front of the police?
Yes, I took the phone.
And from where did you took it?
I took it from the bed. It was near the pillow.
Did you hear any of the noise at night?
No.
When you saw the body,
When you did you see any kind? Did you see the body?
No.
No, you didn't see it, right? Okay, thank you. Your Ladyship, may I call the next witness, that is Palak Gujjar?
Yes.
Answer and
Palak Gujjar, how was the relationship between Dr. Asim and Aisha Yadav? We cannot hear you. We cannot hear you.
Can you hear me now?
Yes.
One second, please. Can you hear me now?
Yes.
Initially, it was a really good bond, but after that, Rasim was being really abusive towards Aisha.
Okay. And did you see that he was abusive with Aisha? Or it's an hearsay?
No, sorry, can you repeat?
Did you see Rasim Khan abusing Aisha?
No, I did not see it.
Then you just heard about it, right?
Yes,
And you heard about it from whom?
Aisha.
Thank you.
We would like, Ladyship,
Ladyship, she just heard about. Thank you, Ladyship. Can we call the witness?
Time is up, I guess. Now it's for rebuttal only.
Okay. Should we start? Your Ladyship, should I approach that? Should I? Am I audible?
Yeah.
Okay. Firstly, I would like to report that the defense have stated that it is an FIR number of 2020 dated 12 May 2020. And below they have written the date as 14 March 2023. So what did happen in these 3 years? Then their issues, they have also mentioned in issue number 3 that they have mentioned that no new trial for improper admission or rejection of evidence is done. Well, under section 167, they have clearly stated has already rejected the stolen evidence from the crime scene. But here, according to the facts, no earlier done.
And your Lordship, in the issue 2 of the defense, they have stated section 24 of the Indian Evidence Act, in which they are that confession caused threat or promise when irrelevant in criminal proceeding. And this is about Aditi, where Aditi is not being induced or threatened for the statement she has given. Whereas in explanation, and that is argument, they have also mentioned that Aditi Gujjar is the best possible position.
Whereas they have also mentioned Aditi Gujjar as the victim.
and also stated that Aditi can do the murder herself, whereas Aditi is a minor of 10-year-old, and how will she able to hold a pregnant lady and twist her wrist with and also hang her? That is very irrelevant.
And they have also mentioned by clause 4, clause 4, clause 4 everywhere by various clauses they have mentioned in their arguments. But clause 4 of what? According to the which statutes?
And in the facts which they have mentioned that they were married under Special Marriage Act, which is not mentioned in itself, and said, may I continue, Your Ladyship? Can we start with the prayer?
I think your time is up.
Thank you.
Hello. Can we, Your Ladyship, can we proceed with our argument for defense of the accused? Thank you. As rightly mentioned by you, Your Ladyship, on this issue, the murder trial is supposed to be preponderance of possibilities and be not only beyond doubt, but beyond reasonable doubt. Even the Supreme Court, as per Article 141 of Constitution of India, has very clearly specified that the law declared by Supreme Court is binding on all courts in India, including this court also. Now, we got a statute, we got a substantial law, we got procedural law, and there is an evidence act. Now, investigation officer and police team, they have not applied their mind. They should have thought about innovative ways to find out that is there possible that accused Dr. Qasim Khan can invite his wife, murder her and hang her, and they can put him charged for murder. It is impossible. No possible accused can think of that. And if he has that intention, which is mens rea, which is not reflected in his invitation and repeated attempts to call his wife to come for a discussion and reconcile the matter. Now, what can be the possibilities? There can be a number of possibilities. One, the victim might have done suicide. Second, even though Dr. Qasim Khan's house, the victim has died under I can say under suspicious circumstances. Number
So
three.
what is your take? What is your take on last scene theory then?
My take is very simple, man. Dr. Qasim Khan, a highly educated person, is a renowned professor.
No, I don't need to understand his credentials. I just want to come to the point. What is your take on last scene theory, that he was the only person to be last seen with his wife, that is the victim over here?
No, that is what exactly the police investigation department has done it. They should have thought that the postmortem report that specifies the time of death is between 4 a.m. to 8 p.m. Now, Dr. Asif Khan already left at 7 a.m. Now, in the Supreme Court judgment of Ram Naresh Chaudhary versus State of Bihar, so in the All India Report of 2001, SC 1428, SCC 2001, Supreme Court has mentioned very clearly that if there is a beyond reasonable doubts or any doubt is there, you must not consider the accused should be in a position unescapable. Now, Qasim Khan, where is? Number one, he left for his college. He left at 7 o'clock. Now, the alibi is one of the valid defense. Section 11 of the Evidence Act, which specifies the facts which are not relevant become relevant. And the Qasim Khan's alibi was not looked after at all by investigation department. Number one. Number two, the mens rea, intention of killing her. What he could have thought it. If he want to eliminate her, he would not murder her. If he wanted to have another hearsay evidence was there that he had rumors about some affair with some student. But that are all hearsay evidence. And a sensible educationalist, if he wanted to do away, he could have applied for divorce. And he was a Muslim, he was from another category. They could have got a divorce under Special Marriage Act also. Number 4, next point. Police had not used any innovation technology. What is happening? Call detail records, position of the mobile phone, what time, who were there, how many people got interest. Now, the main important thing is that secret of this case is deep inside. 24 weeks footage in the postmortem report which is mentioned. If you see the death on 12th May and calculate 24 weeks, it will come from December 2009. And from 2018, there was a discord going on between them, between the husband and wife. Now, the intention to kill, if that is a murder, or intention to suicide, if that is going to a mind of the victim, is only the reason of footage. Because Dr. Qasim Khan had a serious doubt about the parenthood of the king. Now, there is a technique, medical technology is available. If police could have taken the swab of the cheek of Dr. Khan, if they would have taken the sample of the victim, they could have arrived to the parenthood of the fetus. Because beyond 4 weeks, the fetus gets a life. And 99% results of this test show who is the parenthood. And this is the technology used by all over the world, including USA, to establish the parenthood of the child in the womb, to decide the cases for property or for inheritance of the things. But police had not shown anything. They just went by what is easy for them. What they are not investigated about what can be other aspects. If the investigation would have been innovative, you would have thought many aspects which has gone unnoticed. There is no mention about the postmortem report. If you see the postmortem report, your ladyship, it's very clear. There is a bone, hider, which is broken. Now that will happen only when the person is taking a jump with the neck hang at a gauge of 6 to 8 feet. Otherwise, hider will not grow.
No, the person, the bone which is fractured is the hyoid bone fracture.
Yes.
Okay.
Absolutely.
So what do you propose? It only happens in the case condition where the person is suspended from a rope, or yes, it can happen only by strangulation as well, because the postmortem reports also talks about strangulation. There is loss of breath by the deceased person.
Absolutely, you are right.
Which is not possible in the case of suicide.
Absolutely right.
There is an external
suicide. When the victim entered in the house, there was no injury. But when she found dead, there was the injury as per the postmortem report. Now, what I am coming to the point is that if there is some resistance offered by victim, to her.
There were, if you read the fact sheet, there were several wound marks
Yes,
on her
that is what
entire
I'm coming.
body,
That is
which
what
will
I'm-
not happen in the case of suicide.
No, that is what, madam, I'm coming. If there is a resistance offered by the victim to the person, who can be? One, it can be Dr. Qasim, as thought by police, or Mr. Yash Gajjar. He can be other things, or any other third person like Palak Gajjar. Anyone, they can come. What is the time remaining now for this? What is the time remaining?
Yeah, continue. You continue.
Okay. So there is a preponderance of probabilities, and the postmortem report very says, and you see the suspicions, how the needle of suspicion is moving around. Yash Gajjar says that he will do ethical hacking and open the phone to prove that. Now, what the mobile phone recording says, 10 p.m. to 5 a.m. 7 a.m. Dr. Qasim Khan left, and then up to 8 a.m. there is a possibility of death. So the period which mobile phone recording is done is the period where the Yash Gajjar was very sure he was not there. But then when he was there, after 7 p.m. Another important point, Yash Gajjar could not explain how he entered. That question remained like that.
But that is immaterial. How he entered the house
But
is
then
immaterial.
if he has entered illegally.
Let me complete what I want to say. The very fact that your client, the accused over here, was the last person to be seen with the victim, first of all. Secondly, there is no evidence on record to be very correctly stated, except for Mr. Yash Gujjar's statement that this fellow Rasim Khan left the house by 7 p.m. or 7 a.m.
7 a.m. Now,
there is no evidence also on record. It can be that he must be there till 8 p.m. or 8 a.m. also.
No, but we go by fact. And it was the inspection department job to check the alibi. Now, Supreme Court has mentioned in the Markande case very clearly that if the distance which is between the reporting time and the crime time, if that place is having more time that accused cannot reach to create alibi, then it will not be considered. But the police department should have investigated that the time of death was 4 a.m. to 8 a.m. and 7 a.m. left person, Dr. Rasim Khan, he reached to the institute, and that point they are not calculating. Now, my point
but the judgment doesn't talk if that person was the last seen person.
Yeah,
it doesn't talk the judgment which is citing here.
I will come
Can
to that.
I take that? It's my turn.
Madam, I will come to your judgment of last seen together. That is a theory which is used by the investigation department. Now, who are the people were there inside as per the fact sheet available?
There were only two person that leave the minor child. It was only the one person who is the accused over here in picture.
Yeah, one, but before the 3 people were there, or 4 were there. One, Yash Gajjar left at 10 a.m. Then 3 were remaining. 3 were out of that 1 girl. It is mentioned very clearly. She was sleeping in the guest bedroom. So she has gone to bedroom. The last seen person, as for her also, no one knows, has gone Dr. Rasim Khan and his wife. Now, this last seen person, if he is supposed to be together, then that evidence should be corroborated. Why a person should kill his wife in his own house?
No, but you mean, as far as the rebuttal which was made by the other team, do you say or you propose to put forth before the court that the minor child has tried to kill that lady?
No, I am not telling. Minor child is a link to Yash Gajjar. She is influenced by the Yash Gajjar.
Even if she is influenced by Mr. Yash Gajjar, will she try and kill a pregnant lady?
No, not at all. Our submission is not that.
Then the only person remaining is the accused person over here.
Her silence has helped the Yash Gajjar. Her silence.
She has not witnessed anything. She has not witnessed anything, first of all.
Madam, there is no
Do you propose or you put forth across the court that this lady, this girl, minor girl, has seen anything? Is there any witness to that record?
We remember, we mentioned very clearly, because her silence in the statement that she had not seen because she is silent also Yash Gajjar and Palak Gajjar.
Now, council, are you aware about some judgments wherein silence doesn't always means to a yes or a no? The very fact that the minor child was not a witness. So when a person is not a witness to any act, how can her silence or her words mean?
Madam, we are not talking about she is a witness or she is a prime witness or that. We are talking about that our own accused. Who is the person? If his last in theory should be collaborated with the substantial evidence. And there is no evidence, madam. On that, there is no evidence. We are talking about last in person by whom to with whom. Yash has left at 10 a.m. The small girl was there. She went to her guest bedroom. And then Dr. Rasim Khan and his wife, they slept in their own bedroom. Last in theory of who has seen whom.
Madam, may I take that question? It's only fair if I get some time.
Now I will ask my counsel to take counsel number 2 to proceed further. Otherwise, we will run short of time.
Your Ladyship, am I audible?
Yeah.
What we have proposed is she's involved in the murder. We have not said that she has made the murder. She's a 14-year-old, firstly. She can be influenced by her parents to possibly drug the lady or even take the phone away from the lady. That has happened. I'll quickly come to the issues. For issue number 1, we've stated section 102 of criminal CRPC, and the procedures have not been followed correctly. Hence, the second mobile is not admissible. For issue number 2, I think the prosecution's position is not clear. However, our position is clear. We say that the lady is not the child is not an accused. However, she is one of the family members, so she can be seen in that light. And Section 24 of the Indian Evidence Act makes it very clear that inducement, threat, or promise is irrelevant. It can make a statement irrelevant. Coming to Section 3, whether evidence stolen from the crime scene is admissible or not. Fairly, it again goes back to Section 102 of how you seize your evidences. That procedure would not have been followed in any case. And along with that, Section 167 of the Indian Evidence Act says that no new trial for improper admission or rejection of evidence shall be taken place. It will not change the decision of the court if it already has been taken, and if there is a improper admission or rejection of an evidence. Issue number 4, where they say if they're also okay with not taking a narco analysis, I don't need to argue with that. We have the same stand. With issue number 5, can Dr. Rasim Khan be charged with 316? We're not well clear whether the ingredients of murder, that is the precedent to 316, can be all applied to this, because there's no clear evidence. There's only circumstantial evidence. The only thing being that, like I said in my briefing right in the beginning, the accused is a doctorate holder, and the only thing that's going against him is the spot of the murder. No part of the statements, evidences, or even the post-mortem report indicate any foul play, conspiracy, intent, or even the slightest involvement on the part of the accused. So that defines my position on Section 5, Issue 5. And with respect to that, Issue 6, again the same thing comes, that there is no precedent with respect to Section 300 of IPC. And just to summarize it briefly, my co-counsel is very unpleased with the police investigation. He's saying there could have been a much better method that could have been used. And the rebuttal of the prosecution is simply typing errors, if at all, and misinterpretation of what we've said. And if you want, I can elaborate on the Section 300 IPC, the missing elements of the missing ingredients of 300.
But counsel, I don't understand how are you putting forward your case as a team.
Okay.
What is your points of argument? Instead of going theoretically, I need to understand on facts basis. How are you putting forward that your person is not an accused, or he should not be inflicted with the Section 316 or XYZ? It is only on yes or no that you're saying. I need a fact as well as the law to be, in connection with each other to support your case.
Absolutely, Your Ladyship. Even on page 12 of the prosecution statement, they've only said that the only evidence that they have or to the entire incident is the stolen phone. I don't know if you could call that stolen or not, but the second mobile phone that is in the hands of the little girl. And I don't know how they have made a prosecution statement without any other evidence. That is my stand on that. I have to defend my client. I have to just tell you why he is not the murderer. The onus is on them to prove that he is guilty, and there is no real proof that that is already admitted in the court of law. He's been taken into arrest without any clear evidence. They're all circumstantial evidences. Like I said, barring the spot of murder, nothing else.
Yeah, but circumstantial evidence is and the prehistory between both the person, that is the victim, and the accused person over here, deceased and the accused person over here, clearly indicates that there was some kind of tension, and also your client had mens rea to kill this lady, his wife.
No, he must have misspoke. I'm pretty sure. However, Section 53 of Indian Evidence Act tells you a good character is relevant in criminal proceedings, and Section 54 tells you.
Can you speak slowly?
I'm sorry, I'm short on time. The Section 53 of Indian Evidence Act speaks on the good character, which is relevant in a criminal proceeding. However, Section 54 clearly states that any bad character is not relevant to a criminal proceeding. So your stand would not be good in law.
But that's not my stand. I'm saying it is the facts. What does it say? States.
Yeah, the facts say that, but the law says something else. We're going by the law as well, madam. And the law clearly states that under Section 54, we're not.
You want to say that your client, there was a mens rea for the accused to kill his wife. There's clearly a mens rea.
There is no mens rea. That is what they are. The prosecution is saying it. Again, the onus is on them to prove that. There is no. I don't say there was any intent.
So you just plainly denying that no, it is the prosecution's case. The prosecution has to fix the case or prove it. Case will not define your case properly. You need to defend yourself. I don't see you people defending your case. It is just an yes or no, and then the onus is on the prosecution to investigate properly and to do their duties. Apart from that, what is your innovative technique to show that your accused is not the accused?
Yeah, my co-counsel.
Madam, with your permission, can I answer?
Yeah.
Madam, as rightly put to you by you also, one thing is very clear. The prosecution.
You are not audible.
Time up.
They have to. Shall we go on prayer?
It is to be noted that the 5 minutes for the cross-examination starts now.
Okay, we would like to call upon the investigation officer. I'll already ask my question. When did you get the victim's second mobile phone?
Where is the investigation?
We can't see the witness anywhere.
Yes, I'll not waste time till he comes in, and we're already short on time.
Let him first come.
He has to come and answer.
I'll state the question. He'll start thinking. He'll probably
You can't
answer
catch
right.
a train before the train comes, now. Let the train come first, and then you catch it.
Yes, you are. Sorry, Your Lordship. When did you receive the victim's second mobile phone?
We want investigation officer. We are asked for investigation officer, your Lordship.
When did you receive the victim's second mobile phone? Madam, Your Ladyship, I would request some extra time for this. When did you receive the victim's second mobile phone? Your Ladyship, am I audible to you?
Yeah. I can.
I sincerely hope you can consider this and extend some time to us.
I will.
Your Ladyship, there is a problem because we
Am I
are
audible?
asked, we are asked
Yes,
for
you are
investigation officer, not witness.
When
As
did
an
you-
investigation officer,
when-
you should be witness.
When did you get the victim's second mobile phone?
It was when we interrogated Aditi after 1 week.
Okay, have you reported the said evidence, or has it been reported to you as per the provisions of Section 102 of CRPC?
Pardon?
Has it been reported per provisions of CRPC Section 102?
Yes.
Okay. Have you tried getting information from the said phone through a government recognized cyber expert
Yes.
and you failed?
You can't ask leading questions. You let her state that. You can't ask her.
All right. Okay, that's all. Now, can I call upon Aditi? Your Ladyship, I sense. Okay, never mind. How old are you, Aditi?
Sorry,
How old are you?
I'm 10 years old.
Okay, those facts say something else. Have you spoken about this incident with anyone apart from the parents? Have you spoken about this to anyone apart from your parents?
Please unmute her.
About what?
About the murder or this suicide. Have you spoken about this?
I don't know anything about this.
So there is a statement on record. However, she says she does not know anything about it. That's all I'll ask. Can I call upon the medical officer? How reliable is the statement, Your Ladyship? Sir, with all due respect, how reliable is the range 4 to 8 a.m. for the death of the victim? Is it 100%?
It is reliable.
Is it 100%?
Yes.
And can you be sure that it happened before 7 or after 7 or any of that sort?
No.
Okay. That's all I'll ask. I'd like to call upon Palak Gujar.
Am I audible?
Yes, you are. When did you hear about the incident?
Sorry, I cannot hear you.
When was the first time you heard about the incident?
When Yash called me,
When was that?
around 11:30, 11:30.
1.5 hours. All right. Did your husband return home on the night of 11th May?
Yes.
What time?
Sorry,
At what time?
I can't recall.
Okay. When did your husband leave your house on 12th May?
Around 10, around 9:45, I guess.
Can you be precise? Can I get just last one? I just have one more question.
Just one question, okay.
Can you be precise, madam?
I can't recall. Sorry.
Okay. When did you? Why did you not visit the doctor's residence on 11th May?
Sorry.
Why did you not visit the doctor's residence on 11th May?
I was sick, so I couldn't make it up.
Okay. Thank you. That'll be all.
Highly obliged, Your Ladyship.
Rebuttal. Do we go forward with the rebuttal?
Yeah.
Okay. My primary concern is the fact that on page 12, they have mentioned very clearly that the only evidence to the entire case is the second mobile phone, which they haven't tracked yet, or they haven't cracked for that matter. They don't know what the contents of it are. However, they choose to accuse Dr. Rashim Khan of murder. Apart from that, they've used the word twisted in their a twisted wrist. However, the postmortem clearly says it's not a twisted wrist. It's clearly a fractured wrist. And they've even mentioned on page 20 there's extreme brutality, repeatedly assaulted, and deep accurations. All of that is not confirmed on record. I think that's all we have. So I'll wrap up with my prayer. We hereby pray for grant the following release from the Honorable Court. To kindly please allow this memorandum to quash the FIR against the accused, set aside the conviction and all charges under IPC, cost of the defense, and to pass any other order which the Honorable Court may be pleased to announce.
Highly obliged.
Highly obliged.
time up.
Shall we leave the meeting?
With your permission, honorable ladyship, we are getting done with the competition. We'll be sharing the results in an hour. May I kindly ask the teams to leave the meeting? I kindly ask all the teams to leave the meeting. We'll be sharing the result of the Moot Court competition preliminary round in an hour. Thank you.